Are you Latanya Renee Bryant?
Yes, sir.
Okay. I have,
What you're about to witness is not a single charge, but a full courtroom avalanche. 3 separate indictments, multiple felony levels, and prior convictions that could turn years into life behind bars. The judge hasn't even finished speaking yet, and the stakes are already exploding. This case is about more than one bad decision. It's about a pattern the court says it can no longer ignore. Stay with us, because this hearing takes a sharp turn fast.
that's odd. They're indictments on different days. First indictment, April of this year, you were charged with a third-degree felony of collision involving injury. And it is a third-degree felony, which carries with it up to 10 years in prison. But in this indictment, as well as all the other indictments, the other 2, the grand jury included in the indictments that you have prior convictions, 2 of them on 2000 and in 2009 out of the court next door, the 252nd District Court, for one for aggravated assault and one for delivery of a controlled substance. So if one or both of those were proven true, it moves or bumps up the charge. In this case, a third-degree felony, it becomes a second-degree felony. You're looking at up to 20 years in prison, and you are not eligible for probation in front of a jury. In 25 CR 885, this indictment handed up on July of this year alleges that you committed the second-degree felony, God bless you, of aggravated assault with a deadly weapon on or about June 17th, 2025. And if convicted of this, it's a second-degree felony, but which carries with it up to 20 years in prison. Okay, over there? Yeah. And because of the prior convictions that are alleged, the same aggravated assault and delivery, if all of that was proven true, you were looking at life imprisonment if found guilty of that. There's a third indictment, 25 CR 1110, which was an indictment handed up by the grand jury a month after the aggravated assault with a deadly weapon. And it alleges that you committed the third-degree felony of evading arrest or detention with a motor vehicle, and those prior convictions are also alleged. So if you're found guilty, it becomes prosecuted and punished as though it were a second-degree felony, up to 20 years in prison. So
Let's pause here, because what the judge just laid out is massive. On paper, these started as third-degree felonies. But once prior convictions are alleged and proven, Texas law allows prosecutors to enhance those charges. That's how a case jumps from 10 years to 20 and suddenly to life imprisonment. This isn't the judge being dramatic. This is the math of repeat offender statutes. And notice the pattern the court is emphasizing: bond, release, new offense, over and over. So here's the question for you watching. At what point does the court stop giving chances?
on the 885 and 1110. You know, they must be high. You're in custody. You hadn't been able to post a bond, and I think I know why.
30,000 plus no contact plus GPS remain in Jefferson County.
For what?
The 0885. I just thought with deadly weapons 30,000. You said the 1110?
Yes.
10,000 with standard.
Who said that, Bob?
I have to look at them.
Okay, it wasn't me.
No, sir. The JP in the time, who's ever out of the jail.
They must not have had any clue about
Each one.
this first case that had been indicted, because you posted a bond in this first case on, or a bond was set by the magistrate on April. Then looks like there was a hearing on in May of 25, where the defendant it says
It's a forfeiture.
she wouldn't cooperate with the magistrate. So she was indicted and posted, and a bond was set in May. The next month, it's alleged she commits aggravated assault with a deadly weapon. And then that on 6/18 of 25, they take up a bond hearing. And then on June, I guess she's released because in a week, she's committing a third offense of evading arrest or detention. She doesn't have a bond, does she?
The 445 is 16,000.
No, there is no bond. No, you don't have a bond. It is all revoked. You committed an offense, post a bond. A few weeks later, you commit a second-degree felony of aggravated assault, according to this, and post a bond. A few weeks later after that, you commit a third crime of a second-degree felony. And you are too dangerous to the community, and you're obviously you're going to stubbornly refuse to follow any bond conditions, which include the first thing, don't commit a crime. So you're not getting out until we can try these cases. We're going to try the most serious one first, get this first degree felony out of the way, okay?
Yes, sir. Yes, sir.
Anything, Dad?
Yeah.
That's the rulings of the court. Get ready.
Everybody.
We're going to move this fast. All right, you have.
This ruling makes one thing crystal clear. The court believes public safety outweighs any remaining bond considerations. Based on the timeline, release, reoffense, escalation, the judge finds the defendant too dangerous for pretrial freedom and unwilling to follow even the most basic bond condition: don't commit another crime. The court will now move forward by trying the most serious charge first, a strategy that could define the outcome of everything that follows. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.